Hi everyone, this is Muthumari, the Assistant Professor, Department of Business Administration, Standard Fireworks Radhakrishnan College for Women, Sivahasi. Today we see about the subject 23 GADS 51 Industrial Relation. In our topic, Settlement to Industrial Disputes. Let us see about some of the course outcomes of industrial relations. Summarize the concept and various facts of industrial relation. Enumerate, safeguard employees against exploitation, advance social justice, and improve the effectiveness of the labor market. To illustrate the role of trade union in the industrial setup. Outline the important causes and the impact of industrial disputes, and to elaborate industrial dispute settlement procedures. Now we see about the industrial dispute. So what is industrial dispute? That is, we organized a protest against existing terms and also conditions of employment. So these disputes are symptoms of industrial unrest in any country. So according to the Industrial Dispute Act 1947, an industrial dispute means a dispute or difference between employer and employees, or between employers and workmen, or between workman and workman. So which is connected with the employment or non-employment or terms of employment, or with the condition of labor of any person. Now we see about the settlement of industrial disputes. The approaches and the measures are used for the settlement of industrial disputes in every industry. First one is conciliation. So in our conciliation process, by which representatives or workers and employees are brought together before a third party with a view to persuade them to arrive at an agreement through mutual discussion between them. It involves friendly intervention of a neutral person or group of persons to help the parties to settle their dispute peacefully. So according to the conciliation, the practice by which the services of a neutral third party are used in a dispute as a means of helping the dispute parties to reduce the extent of the differences and to arrive the settlement or the agreed solution. So it is a process of rational or ordinary discussion of difference between the parties to the dispute under the guidelines of the conciliator. For this, the Industrial Dispute Act 1947 provide appointment of conciliation machinery. For this conciliation machinery, we have conciliation officer. The appropriate government may be notification in the official gazette appoint such number of persons for the conciliation officer. The main duty of this officer to mediate in and promote the settlement of industrial dispute, and other duties to hold or coincide the conciliation officer for the proceedings, to investigate the disputes and to settle the report and the memorandums of settlement in appropriate government, to send a full report setting forth in that step in case no settlement has been arrived. For this way, the conciliation officer shall submit his report within 14 days for the date of commencement of conciliation proceeding. For this act prohibits strikes, lockouts, and also the conciliation proceedings in the process. For this duty of the conciliation officer, it is a non-judicial manner only. After reporting that no settlement could be arrived at, a conciliation officer can be deprived from making further effort to bringing about a settlement. The conciliation officer has no power to force a settlement. He can only pursue and assist the parties to reach an agreement. Next one is Board of Conciliation. The Board of Conciliation, still the appointment of appropriate government, have a notification with the official gazette, so that the promoting the settlement of an industrial dispute. The board shall consist of chairman and 2 or 4 other members. Appropriate government also appoint the conciliation officer in that board. The chairman shall be an independent person, and also the other persons appointed in equal number to represent the party to the dispute. A person appointed to represent the party shall be appointed on the recommendation. For that, the period of prescribed time. For the person's duties are, where a dispute has been referred in, shall endeavour to bring about a settlement for the same. If the settlement send a report, thereafter appropriate government together with the memorandum of settlement signed by the parties to the dispute, and if the no settlement is arrived at the board shall soon as practicable after the close of investigation send a report to the appropriate government stating the facts and circumstance, the step taken by the conciliation officer, the reason why no settlement was arrived, and the recommendation of the disputes, it will be given to within 2 months period of time. Next one is arbitration. Arbitration is a process which a neutral third party listen the dispute of other parties, gather information and give some decisions in a blind of the two parties. It comparison with conciliation, it involves compromise arbitration in a quasi judicial process. The conciliator simply assists the parties to come to a settlement, whereas an arbitrator listen both the parties and then give his judgment. So arbitration have many advantages. It is nothing but, first one is parties themselves have a greater faith in that person. The process is relatively expeditious and results in prompt settlement of differences, and it is informal and flexible in nature also. It is not very expensive because parties can directly present their case without lawyer. So it is based on mutual consent of parties, and arbitration suffer from some of the several disadvantages also. Some of this or judgment can become arbitrary when the arbitrator is incomplete or biased in some cases. Then next one is delay often occurs in settlement of disputes, and some cases too much arbitration is not a sign of healthy industrial relation. So it also involve voluntary and compulsory arbitration also. In voluntary arbitration means the dispute parties themselves refer the disputes on their own to an arbitrator. For this way the award of the arbitrator is not binding on the parties. On the other hand, compulsory arbitration, for that compulsory arbitration the parties are required to submit the dispute to the arbitrator when the parties fail to arrive a settlement voluntarily, or when there is some other reasons the government can force the party to refer the dispute for the arbitrator. In such case the arbitrator is binding on the parties to complete the disputes. Next one is adjudication. Adjudication is the ultimate legal remedy for the settlement of industrial disputes. It means intervention of a legal authority appointed to the government to make a settlement which is binding on all the parties. First we see about the court of inquiry. For this way the notification given by official gazette, the court of inquiry given by both the parties. The court of inquiry may consist of one independent person or such number of independent person appointed by government. The court of inquiry has the same power vested in civil court. So every inquiry or investigation by a court shall be deemed to a judicial proceeding. So it is duty of the court of inquiry to inquire matters referred to it and submit the report to official government within a 6 months period of time based on the inquiry. The court inquiry is fact finding body and it requires to make recommendations to settlement in a dispute basis. It also have 3 tier of systems. First one is labor court, second industrial tribunal, and third one is national tribunal. Thank you. Thank you for visiting. Thank you.